you must give priority all the time from start to last the best interest of your child. If you speak to social care, if you speak or had interview with the Kafkas, if you in the court you are giving evidence, always put and give and establish that you are giving priority, primary consideration, the interest of your best interest of your child. Put what allegation you have against your other partner, in other side. But if it is relevant for your child interest, of course you can raise to the court. Another misconception is some people always find it difficult to work with Kafkas and social care because there is conception that Kafkas or social care is the party which is not come to help or is against you. They want to take child away. Well, this is not to be the case. Kafkas social care, this organization is here to help you, to assist the family. Sometimes some parents find it difficult that the court is against them, the social care is against them, the Kafkas is against them, the police or other organization who is involved in child arraignment application or the court process, they are against you. Well, they are not against you actually. They are in the best inside of best interest of your child. Now, when you apply for child arraignment application to the court, whether you apply by person or by through any lawyer, then of course, first step is the Kafkas need to write a safeguarding letter. When they do the safeguarding letter, if they will do have an interview either by telephone or directly, in that case, what actually you have to be conscious with them, you should cooperate with them, be honest with them, and always give priority your child interest. Whether you have a custody of your child or the other party has a custody, one always is what all the authority which they will assess what actually best interest. And you know what, the Kafkas or the social care or any other people, they are the professional, they are working, parents, many parents, and they have experience. When you are telling a story about allegation or your child behavior or what you want to achieve, they basically observe your conversation, and accordingly they prepare a report and they will make a recommendation to the court. And this recommendation, their recommendation, is very important. So don't think that Kafkas is your enemy. Kafkas or the social care, all the organization is come here to help you, to help the family, to help the child. Another thing, uh, when parents are separated, sometimes the relationship is became so awful, and they don't like each other, they don't want to contact each other, they want to talk each other, they want to see face each other. In that time, if when the child involved, is very difficult to work both parents for the interest of the child. Now, in that case, always remember that involving other parents or both parents in the child life is further a best interest, and that was the court always consider. Always try to think whether you can settle this matter without going to a final contested hearing, unless there is an issue of domestic violence. Of course, if it is a domestic violence issue, if you have an allegation, it needs to be do a fact-finding hearing. Safety, security, best interest, of course, if that is an issue for the child contact or the father or mother contact. Say, for example, other parents who apply for child custody or contact order, he has a perpetrator of domestic abuse, or so for example, someone use a lot of drug or drink, alcoholic environment issue, criminal record, all this issue. If the issue is like that, of course, that had to be analyzed, that had to be examined. The court need to see the report, the professional need to see their old report history. In that case, of course, it has to be go through the whole process. If there is no issue of domestic violence, if there is no issue of drug, or if there is no safety or concern about the other parents' ability to look after the child, if it in good position, then put your personal anger one side. Try to settle it for the interest of the child. If you both can work together for the interest of the child, that will give a good relationship with the pair, both with the child. The reason is another aspect what I always advise the client: don't ask or involve children with the child arrangement application. Keep the children out of all sort of things, because you know what? The reason is firstly is of course not the not best interest of your child to speak about what's going on in the court, or the allegation of against the father or allegation against the mother. The other thing is the social care or the Kafkas. They will speak with the child alone in the school, and there, if the child raised this issue, is very concerning, and that will come to the report. So, whatever you say to your child, whatever behave, whatever you think, everything will be in the report. And if the Kafkas or the social care provider Section 37 report or safeguarding letter or Section 7 report or 16 report, whatever it is, that is very important, because the court will read all the report and will assess how you behave. And this is very important for the court. But remember, court will make a decision end of the day. So you need to you can't get a decision by force or by putting something which is not is true. The court will do justice, and the justice will depend what is the best interest. So that is the main thing. So in the child arrangement application, so that is the tips. Always I advise my client to be concerned, because there is some these are the misconception for child arrangement matter, especially when the relationship break down. So I think this is the brief information about what you need to be consider. In terms of application, I had a couple of video in my YouTube channel, but if you want to apply, you can apply online for child arrangement application. C100 form you need to complete. If there is an issue with domestic violence allegation, any allegation concern, you need to complete C1A form as well. If you want to keep confidential information into tell the court and mentioning it in the form. The once you apply, the first what the court will do, court will without hearing will issue a direction, will give direct direction to the Kafkas to prepare a safeguarding letter. So this is the first step, and then will be a day for first dispute resolution hearing. On that hearing, based on the Kafka safeguarding letter, court will decided whether they will settle this matter on that day. If not, if the party not come to a settlement, or if the safeguarding letter raise any concern, then that matter will be listed for first dispute resolution hearing with further direction. So in that point, the court will more likely direct to the Kafkas to give a report, Section 37 or Section 7 report, or the court will give direction to the local authority if they have any involvement. Either local authority will give a report, or they will set up their position in a letter. If police involved, if doctor involved, that will come as well. If any concern regarding drug use, the court will order the other party to do a drug test, alcohol test, mental health. Letter court will direct the letter to doctor to give a letter regarding the mental health. So all sort of things, report from the school, a report from the police. All the direction court will issue on that hearing or first dispute resolution hearing. Now, then it will be listed for dispute resolution hearing. If this matter is good, if there is no concern according to the Kafkas recommendation on Section 37 report or Section 7 report, court will more likely make an order if the party can come in agreement. If not, and then the next step is either if there is allegation of domestic violence, then more likely the matter will be listed for fact-finding hearing, and then will be for welfare hearing. So what is fact-finding hearing? Fact-finding hearing basically to find the fact what the allegation is made, it is true or false. That's it. The court will not make a decision who will get the custody of the child, with who the child will live. This is not the day to make the decision. Fact-finding hearing is only the allegation you made, say for example, you make 5 allegations, other party deny 5 allegations. So in that, the court will basically both party will establish what they're saying, what the fact is, and say for example 5 allegations, court will only decide allegation proved, allegation not proved. That's it, the court will decide. And then more likely court will list that matter for final hearing, or which is called basically welfare hearing. So that day court will decide, okay, basis of what, this is what we have fact finding hearing. On the basis of fact finding hearing, court may direct the local authority or the Kafkas, more like local authority, social care, they will prepare another report, their position on fact allegation, and what is their position and what is their recommendation. Maybe we'll do further investigation, all the sort of things. But anyway, we'll be in welfare hearing. This is the final year hearing where the court will decide who will get the custody of the children, and whether the other party, non-resident parents, will have contract, if how the contract, whether direct contract or indirect contract in a children's center, or over the telephone, or under supervision or without supervision, or in the community. All sort of it depend on the circumstance of the parties and circumstance of the children, of course, and other recommendation report. So all sort of professional report, it depend, and accordingly court make a decision on the welfare hearing, which is the final hearing. And court always make a decision what is the best interest of the children, not what you parents want. So this is a short video about child arraignment. This information is not a legal advice. If you have any question, or if you are concerned, and if you need any professional help, please feel free to contact with us. My name is Suhail Ahmed. I'm the principal solicitor of SWF Solicitors. We are happy to give advice face to face, or take your case if you need help. Anyway, wherever you are living in the UK, we can work remotely to do meeting by Zoom. We can represent you anywhere in the UK court. So thank you very much, all of you, today.